crime. And it might, there's a bunch of abandoned properties out there. If you have to move on, you have to move on.
I have 3 questions. One is, is there a difference in squatting city-owned property? Can you sign the declaration, the homesteading declaration, and the intent to pursue interests as a collective or an organization rather than just like one person? And the third question, I don't remember.
Yes and yes. There is a difference between occupying government property. As I read Civil Code Section 1006, it states that you can never occupy the land and claim title against the government. So any kind of government land, you can't claim ownership of that. That's a big problem they had with People's Park. And so that's why when you're occupying land owned by the government, if you want to keep it, it has to be through political means. It has to be through a groundswell of political support. And the second thing I said yes, but I forgot what the question was.
Is there a difference between city and city-owned property?
No, that's the difference. Yeah, you can well, you can sign. Multiple people can sign the notices of intent to preserve interests or homestead declarations. You can sign them as one group, or you can file them separately. And I know for a fact, quitclaims deeds work that way as well as grant deeds. And technically, you can put anything on the piece of paper you want, as far as from whom to whom, and the recorder will record it. That doesn't mean that it's legally binding. So, I've heard of people filing grant deeds to fictitious entities, and that being them getting in trouble for it. So, you have to make sure that it's an actual entity that exists and that it's a legitimate, it's a legitimate. What your intention is at least legitimate. So, what's the third question?
I was wondering how long, if at all, would you wait to have been in the squat before filing the homestead thingy?
I like to file the homestead declaration the very first day, because under Civil Code Section 1006, occupancy for any period confers title, which means that the moment you enter the property, you become the presumptive owner until someone else comes forward to challenge that.
So can you just go through the steps again of, like, if you were, I'm assuming people in this audience probably are thinking about trying to establish something, and just think about, like, we found a space, we think it's really great, these are the sort of first 5 steps of what I would do if it were me, but it may vary.
Well, where did Mimi go? That's the other Skillshare. So that's gonna be a whole other long thing about step by step how to, like, the best way to logistically do things, to strategically do things, and all of that. Yeah. Oh, is the paperwork specifically? Okay, the paperwork specifically, homestead declaration first, and then you can file, then that allows you to file a notice of intent to preserve interest. And you could file quitclaim deeds at any point. And quitclaim deeds basically is something that's saying that I disclaim ownership of this property in favor of someone else. So you can do that with your Civil Code Section 1006 occupancy interest to another person.
What was the first one?
Okay, and if you haven't gotten these pieces of paper that have these written, the code sections for these documents, they are going around. I know, well, I think she might have walked off, but I have a couple copies, so come forward and I'll give you a flyer with these. But the first one's a homestead declaration, and the second one is a notice of intent to preserve interest. And really, you can file any of those except for the notice of intent to preserve interest at any time, including the quitclaim deed, and any other document really. The only reason the notice of intent to preserve interest cannot be filed first is because the notice of intent to preserve interest has to refer to another document that's already been filed. All the other documents just stand on their own merit, whereas the notice of intent to preserve interest has to, cite that other document that you previously recorded.
Is there any way to file to recoup some money spent in making the house better? Often there needs to be like a lot of work put into squats. Is there any way that you can file for some way to get like money back through like, I don't know, the owner or the bank or somewhat?
That is one of the slippery slopes that happens with squatting. So you occupy a building, let's say all the copper pipe's been stripped, every window's broken, all the paint's peeling off, and the yard is like overgrown. So you buy copper piping, you buy glass, you buy tools, you buy materials, you spend, every paycheck, and you realize, wow, I've spent more money on squatting than I did on rent. And then 4 years and 11 months later, you get evicted the day before your adverse possession claim comes to fruition, and you've turned this dilapidated husk of a building that's falling apart into this beautiful home, and you spent all that money and you paid all those taxes, and then the owner comes in and says, get out of here, and they flip the property after all your hard work. Well, the question is, can you recoup all that money? The answer is there is no guarantee you can. You can, and it depends on how well you set yourself up. It depends on if you avoid the police, and if you've, established yourself with enough credibility that a court views you as someone that they have to evict, basically, and then they have to, if they file, so if you get into that position, the owner will file a quiet title action and ejectment. They will start that process to eject you because that's the process. And you can technically sue them for unjust enrichment in reverse and say, you're being enriched. Your property is now $100,000 more valuable than it was when I entered into it. You can get appraisals. I like to get appraisals. I'm a nerd. I like to have someone appraise a property after I crack it and then get an appraisal later on when I get sued. And hey, this is $100,000 more valuable. You owe me $100,000, and then you might be able to get your money back. And in Banana House, which is a very notable squat that I was doing, we fixed all the windows, we did all the landscaping, we redid all the plumbing, we paid all the property taxes, and we spent thousands of dollars on that squat. And then I went to jail and I served time, and then I was sued after the fact, and I was able to recoup $10,000. So broke even. That doesn't pay for all the time I spent picking up trash on the side of the road, but it does help. You could get the money back. It's not a guarantee. You have to be engaged in the process and you have to follow through. Most people do not, and most people just write that money off.
So I have two more things that I think I want to hear you talk about. So there's one is the legal differences that you may have with the commercial space versus a residential space, and the other one is with BankOn, the whole cash for keys deal, which is really, really awesome.
All right, well, you just reminded me of all my nightmarish experiences with code inspectors. So yeah, commercial property that is zoned for commercial purposes, you have to squat it for commercial purposes, or the code inspectors will come in and there have been squats that have been evicted not by the police but by code inspectors because you're not conforming to code. So if you go into commercial property and then you subdivide it into a bunch of bedrooms, you could, even if you defend it against prosecution by the police and an eviction otherwise, you could see a next wave of code inspectors coming in and saying, get out, because this is not a residential property. And cash for keys with foreclosure properties is a common occurrence, whether you're a tenant or even a squatter. Somebody wants to get you out of the property and says, here's $1,000, please. And it happens, and you just have to ask yourself, is that worth it? Do I want to fight for the property? most people I know, when they're offered with a cash for keys situation, there's a balance of, you know, is the jig up, and is this over, and do I have, can I fight this, and will it go anywhere, and so should I just take the cash if I'm going to lose anyways, and I leave 1 month earlier or 2 months earlier, or can I fight this and can I hang on for this? And I've seen it go both ways, and I've seen people refuse cash for keys and hold on to a house for years, and I've seen people accept cash for keys, and I'd like to think that at least they negotiated pretty strongly with whoever it was for that. Oh, the bait and switch. Oh. You've been to Hilarity, haven't you? Yeah. Yeah, I think you're referring to a bait and switch. No, you can't do that, although it has been done. So I don't know how that. But Hilarity's a magic place that all rules of logic and reason and physics don't exist. But yeah, if you do cash for keys and then you go back in, usually cash for keys is a contract, and if you take the cash and give them the keys, and then you go back in, you're in breach of that contract, and you're. Well, yeah, I mean that's like the Hilarity situation, where people they sued 30 people, and they thought like, oh, this is the leader, I'll just give him cash for the keys, and they kept doing that, and they realized, wait a second, every time we do cash for keys with their leader, some other leader shows up and says, hey, I'm in charge here, and so yeah, I mean, if it's just cash for keys, but the person that comes in after could be prosecuted for trespassing because they're not the tenant at that point. So do you want to come up here so we can hear you?
Actually, I don't need a microphone.
Okay,
You
go.
can be better than that. All right, there's a couple members here, members from Hazmat. We had kind of a corrupt zoning thing going where we could have been protected by the Slumlord Protection Act, except it was zoned industrial, so therefore it wasn't applicable.
Yeah, I don't have it. That's more of a statement than a question, but you. Well, I think and that's not really, it's a landlord-tenant issue, so I'm not really the most. But the one thing I do know about situations similar to that is that a lot of people get buffaloed. A lot of people occupy property, and you could be a tenant, you could be in a foreclosure, and we have just cause eviction ordinance in Oakland. People fought really hard for that. And there's a lot of protections supposedly in Oakland, and people fought really hard for that. Yet still to this day, landlords will come in, banks will come in, lawyers will come in and say, you have 3 days to get out of here. It's totally bullshit. But they still say it anyways, and they hope that you don't call them on their bullshit, and that 3 days later you're gone, or a month, or at the end of the month you're gone. And I would, the lawyers that I've talked to about this say that more than 90% of all residents in properties are tricked into leaving because they don't know their rights, they don't think they have any rights, and so it's in situations like that I would just be as assertive as possible. And I think that there was other issues going on with Hazmat that created a disintegration of the household, so it was harder to pursue, maybe, I don't know. But I think sticking to your guns is, if you are a tenant or someone that owns an owner-occupier of a building that's been foreclosed, you have a lot more rights than people realize, and so it's really important to fight for that. And if you're a squatter too, if the police aren't getting involved and they're not dragging people off to jail, hold your ground. They can't just, because we've had situations where squats have had the owner show up with thugs, and I've been in one of those situations where they just get some lead pipes and start smashing things up. That's not, you can hold your ground, and that's not a legitimate way to get evicted. And, and you just have to gauge like how much you're willing to fight for your space. So anyone else? I think we're running out of time.
Just following up on the other one. So if a group gets cash for keys, is there any repercussions for that group if another group then occupies the building?
Well, like I said, cash for keys is a contract, and so it depends. If there is nothing more than they got cash and they handed over the keys and there was no word spoken, nothing in writing, then yeah, it would be impossible for those people to really be held liable for that. But often, cash for keys is actually written out by a lawyer who says, you know, we want you to sign this agreement, we'll give you this much money, and then you're going to leave that property at this date, and they usually add clauses. And so really people need to look at those contracts before they let somebody do that. Any more questions? I think we might have another Skillshare coming up. So Mimi, tell us what's going on, and tell them when we're going to talk about strategy.
Okay, so